Right, it's on. We can go.
Thank you. My lords, my lady, I was in the midst of making submissions about Article 67,
Yes.
which I will continue with. Just 2 points. I'm very sorry, but I forgot to do this at the start of the day, but there is something I wanted to hand up. This is specifically on the issue of competent institution, and it's the decision of the CJEU in Coppola. It's just there's a part of the Advocate General's opinion where they essentially say one only looks at Roman numeral 2 if Roman numeral 1 doesn't work.
I was wondering whether there was any implied order of precedence between them.
Yes. So I will, for your reference, is page 592. That's the only reason I cite it. So I'll leave some copies here and leave it at that, if I may. And then there was a point that I missed in relation to Article 7. In fact, it was a point made by the bench, I believe, which is that where Regulation 883 seeks to limit or exclude Article 7, that's normally done in express terms. And that's dealt with at paragraph 28 of my skeleton. That's just a further point in support of my interpretation of Article 7. So if we can come back then to Article 67, which is where we were, page 45 of the bundle. And my lady had asked a question, well, doesn't this only apply to family members, essentially? And
yes.
my submission is it does not. It applies to both family members and the person entitled to benefit. So the question is, if one looks to the first sentence of Article 67, a person shall be entitled to family benefits in accordance with the competent member state legislation, including for her family members residing in another member state, as if they were residing in the former member state. So the question is, is that referring to just the family members, or is it referring to the family members plus the person entitled?
Well, it's just the heading again.
Yes, my lady, yes, I note the heading.
Well, I mean, the heading may suggest that is the main thrust of what follows. On the other hand, you're perfectly entitled to say, just reading the text as it stands, it does appear to be doing 2 things. Firstly, laying down a general principle, and then making clear it also extends to family members in other member states.
I do, my lords, my lady, rely on the text. And I say, the text, in particular, the use of the word including, points to an interpretation that it's the person entitled and the family members. Why else would one put the word including in there? And I say that interpretation is supported if one contrasts Article 67 with the predecessor, Article 73, tab 3, page 221. Might I just ask your lordships and your ladyships to turn that up briefly? Tab 3, page 221.
Sorry, I do follow you, but it may be my fault, but it's including for his. That a single person is entitled to benefits including for his. So it's not an entitlement of the other family members. It's an entitlement of a person for family members residing elsewhere.
Yes, and the question I say is whether...
But you say including for him or herself and for others.
Yes, whether they refers to both. I don't need this point to win, but I say this is the correct interpretation. And I say if one compares this to 221, Article 73, there we see a provision which is quite clearly only in respect of the members of the family. No including there. Person subject to legislation in respect of members of his family. That's to whom it applies. So I say there must have been a reason for that change. And I say the reason is to make Article 67 apply both to the person entitled and to the family members.
And you wanted to do more because you want to say it reinforces the fact that it's a competent member state, which is the state of application for the benefit, and the individual can choose. Otherwise, it wouldn't matter.
Well, the effect of my interpretation being correct is that it doesn't just cover the situation where the individual concerns family members are abroad, but it also covers a situation like this, where the person who's actually entitled is also abroad. So, on my interpretation, it would reflect or track the effect of Article 7.
Yeah. But it also means, if you're right, that this article limits matters in this way. It applies to the person who claims the family benefit. He gets it or she gets it from the competent member state. That is the member state which includes the institution where he first applied for it. So you're saying that one of the things they intend to do in 67 was the worker who comes from Poland to Germany, then France, then England, is stuck with Poland benefits throughout.
That's the work that the competent member state does. That's my main submission in Article 67. That's
and
correct.
That's a big change from 73, because 73 wasn't trying to do that.
No.
73 was just bringing in the family members, but 67 is actually not just protecting the family members, not just protecting the individual, it's limiting the individual to the place that he first applies for child benefit.
It's providing...
Unless he chooses to apply elsewhere.
Indeed, that's it. It's providing for the possibility of retaining a right. So this is the effect that I ascribe to Article 7, I'm saying on this interpretation, could also be ascribed to Article 67. But as I say, I don't need to win another argument because I've got Article 7.
This is not, I hope, unhelpful, but it's not where you are in your submissions. But can I just ask this? On your analysis of the competent institution, does this mean that somebody who applies for child benefit for the first time needs to understand the impact of that decision? Because it means that he or she is confining herself forever and a day to the state benefit system, say, of this country, without knowing, or that in 10 years' time, for totally unforeseen reasons, he or she marries a foreigner, wants to move abroad and work abroad, goes somewhere with a much more advantageous system, but is nevertheless simply incapable of tapping into that. So that the consequences of the first application are enormous on that analysis.
My lady, it's not the... It doesn't boil down to the choice of the person to make an application only. It's the fact that they're also subject to the legislation of that state at the time they make the application. So it's correct, and there's a good example of this in one of the CJEU decisions, I think it's B, which I'm going to take the call to in a moment, where the person's subject to the legislation of France, as I recall, and they start to receive benefits. And yes, that has implications as to their ability to rely on other benefits. But I don't think it puts them in any worse position. It's a benefit essentially. This is a feature of the regulation that is essentially in favour of individuals, because it allows a person to retain a benefit in circumstances where under the domestic law they would not be able to retain it. If they move to another country and they become, or start working in another country and become subject to the legislation of another country, then that country is open to them as an avenue for applying or obtaining rights pursuant to the legislation that applies there. So no, it doesn't. I don't see. I don't say that.
It could be much better.
I'm sorry.
It could be much worse. It could be much better.
It could.
We just don't know. But there should be a health warning on every application, shouldn't there? Saying, beware. What you're doing now is your final decision for the rest of your child's life. I don't want to be difficult, but I mean it is a very significant thing.
But it's to the benefit of the individual, because what it puts them in a position where they apply for child benefit from the UK, they receive it, they move to another country, the child benefit situation there may be less advantageous, and they may not do anything which means that they automatically receive a requisite benefit. So in that situation, they do have a choice. They could make an application for child benefits.
Well, assuming the legislation of the state that they're going to works on the basis of applications. The health warning is, if before you register in Poland, think, one, will you go to another member state? Two, think which one and check that their social security legislation requires an application. Step three, don't forget they may change the legislation, and if they do, you're stuck. And that's what the draft is intended.
Yeah, well, the regulations have provisions for dealing with those situations of overlapping benefits.
Yes.
So it's been envisaged. It's not something that has been envisaged. So
Thank you. I took you way off course. I just wanted to ask you that question.
It's there, and the regulation envisages it and deals with it.
Sorry, just before we leave Article 67, you were submitting to us that the word "they" in the third line refers back to both antecedents, as it were, to the person entitled to family benefits. And I must say that seems to me at the moment a remarkably strange reading.
Yes,
It says it's including for his or her family members residing in another state as if they were residing in the former member state. So, surely that as if clause can only refer to the immediately preceding family members.
and plural and singular.
Everything seems to me to point to that as the only reasonable reading of that.
My lord, I don't have anything to add really beyond my submissions. I'm relying on the contrast with the predecessor provision
Yes.
in particular.
Well, I follow that, and I also take your point. You say really Article 67, if you disregard the heading anyway, does open with a general statement that a person shall be entitled to family benefits in accordance with the legislation of the competent member state, not the member state of the applicable legislation. And that stands or falls with a lot of your other submissions as to whether there is that clear distinction being drawn really throughout Regulation 883 between those two concepts, or whether they're just really very often two ways of saying the same thing.
Yes, well, the court has my submissions on that, but on this particular point, I don't need it.
No, I follow that. Thank you. So I really just wanted
a bonus argument.
Yes, well, I was really just coming back on what at the moment seems to me a rather difficult argument that the word "they" refers back to everything that goes before as opposed to the immediately preceding clause.
So, my lords and my lady, really, the important argument in Article 67 for me is the fact that we've now got competent member state in there. My learned friend, I say, not spend a lot of time on the wording of Article 67, but she did submit that Article 67 and Article 73 have precisely the same meaning, and that was based on the authority in Moser. I don't think we were taking that, so can we just take that up, please? It's tab 19. And it's paragraph 36, that's the relevant paragraph, which is at page 791. So it's page 791, paragraph 36. And if I might just invite the court to read paragraph 36, please. What I say about that extract is the court there is saying that the two provisions are essentially identical, quotation marks, in seeking to effect the objective of making it easier for migrant workers to draw family allowances in the state where they're employed, etc. So it's dealing with a specific and quite general point, and as against the points that I've made about the difference between the concept of competent state and applicable legislation, and the way that was analysed in Tolley, and the change that was introduced between the two regulations in terms of the wording, I say that that is a slender hook on which to hang a submission that the two articles have the same effect in every respect.
Paragraph 37 is quite interesting, isn't it? Accordingly, Article 67 is applicable to a worker who works in a member state but lives with her family in a member state other than the one whose legislation is applicable to her.
Yes, well, I mean, I wasn't. My interpretation didn't exclude that possibility. Well, those are my submissions on the wording of Regulation 883. I might come back to. I'm going to come back to the provisions on overlapping, just to make my points about the need for an application, whether the benefit needs to be being paid. But can I just deal with the case law on retention of rights, and on the cases that my learned friend relied on? Really, my headline point is that almost all of the cases referred to by my learned friend, and certainly the cases that she positively relied on, do not deal with retention or acquired rights. So they are of limited assistance. My learned friend, it appeared to me, relied particularly heavily on effing at tab 7. And effing does not assist the court, I say. Because it doesn't deal with the issue of retention of a right where the applicable legislation changes. That's not surprising, because effing is a 1408 case. It's a family benefits case under 1408. And as I've already shown the court, the family benefits provision in 1408 is based not on competent state, but on applicable legislation. And I've already made the submission that basing provision on applicable legislation essentially cuts out the Tolley analysis, so you're not able to say at this point in time you've acquired this right. So it's not surprising that the court's not dealing with retention of right. It doesn't assist us. That's really my main point in effing. I'd also highlight the question asked, which is set out at paragraph 18 of the Advocate General's opinion, page 374. There's denying child entitlement because the father serving a criminal sentence handed down in Austria in his member state of origin constitute discrimination against that child. Well, that's the question that the court was answering, and I say there's very little between that situation and the present situation in terms of analogy. Really, it seemed to be being cited for the change of applicable legislation, but I've already dealt with where I say that concept fits into the framework of Regulation 883.
And I think, to be fair, the main reason Ms. Smith was taking us to those authorities was really for the emphasis they place upon the very great importance of the applicable legislation and the way it can lead to consequences which might at first blush seem a bit surprising. And it was really to reinforce the preeminence, as she would have it, of that concept.
Well, there's no quarrel on that general level.
Yeah.
It's just a question of how it applies in this context. There was also reference to B, tab 14. This, again, is a case which doesn't deal with retaining the right to benefits that's been acquired pursuant to the legislation pursuant to legislation A, where the applicable legislation changes to legislation B. Tab 14, yes, tab 14. And the point was made, well, how would Article 7 the point was made that there's friction between this case and the upper tribunal's reasoning, and I said there is no such friction. Here, the applicant is subject to the legislation of France and actually receiving benefits in France. She's receiving a maternity allowance, and then once under domestic law, her entitlement to benefits ceased, she then applies for benefit in the Czech Republic. So it's just a straightforward...
Why wasn't the competent state, paragraph 13, last sentence, Mrs. B applied for family benefit in the Czech Republic? Why then is the Czech Republic not the competent state?
Well, all that's
competent
happened...
institution is the Czech Republic institution.
Well, the law of the Czech Republic does not apply to her. I mean, all that's happened, as I understand it, is that under the domestic law, that benefit has stopped. Nothing's changed in terms of the applicable legislation. It's just a straightforward application of the rules on applicable legislation and the competent institution. There's no scope for Article 7 to operate in this context. There's little by way of analogy.
Why doesn't she rely on 67? She wants benefit, and she's applied to the competent institution.
Because the legislation of the Czech Republic does not apply to her. The only connection she had was that she had a property that was registered in the Czech Republic.
Is this a case where there's this rather mysterious concept about being registered as a permanent,
that's the one.
permanent resident?
But it appears, whatever that means, it appears she wasn't living there.
I mean, that seems paradoxical, doesn't it? If you're permanently resident somewhere but don't live there.
Well, she's registered as having...
Had some kind of permanent establishment. I mean, that's a misleading expression to use in this kind of context. But yes.
My lord, the nub of it is at paragraph 25.
Yeah.
She remains subject to French legislation. So it's just a straightforward application of the Title II rules. The one case that deals with retention or export in the context of family benefits is Kuzijavi. Kuzijavi at tab 6. And I learned friends already been through it. I take the facts from page 329, paras 21 and 22 of the Advocate General's opinion. Swedish national, entitled to family benefits and receiving family benefits in Sweden. Moves to Finland and wants to continue receiving Swedish family benefits. Facts are pretty similar, actually.
Sorry, which were those paragraph numbers?
I'm sorry, it's paragraph 21 and 22.
Thank you.
Perhaps I'll just leave the court to read them.
Yes, absolutely. I guess I hadn't noted them down.
So the question, the relevant question is set out at page 352. Page 352, and it's the subparagraph 3 at the top there.
that a relevant question for us?
This is the question that the CJAU was considering at the time. It's relevant for us because you'll see that my lords, my lady, you'll see that the question is framed in terms of it being maternity benefit, but actually the court concludes that it's a family benefit, and that's at page 362, paragraph 60.
So what am I supposed to get for the case at the moment?
Well, this is a case where the court ultimately concludes it's a family benefit, so Article 22 doesn't work. So then they go on to consider, well, can this benefit be retained / exported anyway as a family benefit, which is the issue that this court is considering. And the relevance is in paragraph 72, which my learned friend took you to. So the points made at 72. Well, Article 10 does not apply to family benefits, and then over the page. In light of the foregoing considerations, one of them being that Article 10 does not apply to family benefits, the fact that the law, that she loses her right to continued payment of family benefits is not a problem. So I say, well, it's pretty straightforward, that the court is essentially saying there were family benefits to fall within Article 10, then the position might have been different. That's essentially it. That's the closest I think the CJU gets to the question before the court, and I say it's telling that the appellant sought to deprecate that decision. I'd also note that that decision is referred to in the recital 34 to Regulation 883. Right, so of the 5 parts of my submissions, I'm now on the 4th, which is Article 68 and the implementing regulation. This really relates to ground 2, but as my Lord Lewis pointed out, the issues that arise here do feed into the question of the questions on the ground 1. In terms of the upper tribunal decision, the relevant paragraph is paragraph 9, which we were taken to earlier. Perhaps I can ask the court to just take that up. Page 38 of the core bundle, tab 6, paragraph 9. Now, I have to say that when I read that paragraph, I'd understood the upper tribunal judge to be saying that there was a requirement for an application. But as I'm going to show the court, the regulation and the implementing regulation, I'm going to say, make it clear that an application is required for the mechanism to work. So it all presupposes an application, that's what I'm going to say. And then the case law of the CJEU does go as far as saying that the benefit actually has to be paid for the overlapping provisions to kick in. Also, I may be being kicked in, but for my part, I have some trouble in distinguishing between a situation where all domestic preconditions have been met for a benefit to be paid and a situation where the benefit is actually being paid. I'm not sure what the practical difference is between those two
Well,
situations.
you may have satisfied the requirements, but for whatever reason not have been in receipt of benefit. You may have to provide, for example, a copy of the birth certificate. And if you haven't provided a copy of the birth certificate, then you wouldn't get the money.
But
If you have got a copy of the birth certificate and you have supplied it, then you can get the money, but they won't have paid it. So the conditions are separate from the physical receipt or transfer.
But those kinds of procedural conditions are generally included within this idea of the domestic preconditions, such as making an application. So on that view, where making an application, putting in a birth certificate, providing the relevant documents is part of the domestic preconditions.
Yes.
I query the practical distinction. Now, I'll start with the implementing regulation, if I may. So that's tab 2. Tab 2. And the submission I make in relation to Article 59, so we were taken to paragraph 1, significant time was spent on paragraph 1. And I should deal with this, the reference to applicable legislation here, which was really the textual crux, it appeared to me, in the appellant's case on ground 1. Well, the point I'd make there is that that language is not in Article 67, it's in the implementing regulation. So we can't rewrite the main regulation in reference to the implementing regulation. And for my part, my learned friend may correct me in reply, I struggle to think of a situation where a state's legislation is applicable, it pays benefits, and yet it's not the competent state. Struggling so far to think of this scenario where that arises. Now, the point that I want to take from this is that paragraph 2, which I think less time was spent on. If I could just ask the court to read paragraph 2, please. And the point I make there is that it presupposes that everything has been done such that benefits can actually be paid. Article 60, to similar effect. I can just ask the court to read paragraph 1, please, of Article 60. So the first sentence, again, presupposes that the starting point is an application for family benefits. And the third sentence in particular, which starts where a person entitled, so where a person entitled to claim the benefits has not exercised his right, then application may be submitted by the other parent. It's very difficult to see how those mechanics would operate without an application.
Just thinking out loud, sentence 1 of paragraph 1, the application for family benefits shall be addressed to the competent institution. Presumably, if you'd moved to a country where the law was more favourable and you wanted to apply for benefits, you could do so.
Yes.
And you would be applying to the institution of the country with the favourable legislation.
Yes, as long as that legislation was applying to you at the time you applied.
So when it says competent institution in the first sentence, it appears to be the case there that competent institution may at least include situations where the competent institution is where the application is made to get benefits for the first time in a new state.
If Miss Carrington had made an application for child benefit to Spain,
Spanish would be competent.
yes,
So it all does hinge on the right of choice. It all hinges firstly on domestic law requiring an application, and secondly, the individual making such an application.
yes, that's of a piece with the fact that it's a conflict of law mechanism for social, for benefits. I say that's when it bites. To similar effect, second paragraph of paragraph 2. And also second paragraph of paragraph 3, which all deal with matters consequent on the application being made. Certainly, in the scheme of the implementing regulation, it seems to be assumed that family benefits are awarded following the grant of an application. Just by way of context and to similar effect, can I show the court briefly, please, Article 81 of the main regulation, tab 1, page 53.
Sorry, did you say 80 or 81?
81, my lord.
81.
Page 53. And that's just setting out the mechanics, so that if practically where it would arise is where the competent institution is, where one is not living, one could make the application to an institution in the state of residence, which would then have to transfer it onto the competent institution. But that's in a situation where there's no risk of the state of residence being the competent institution. And just, sorry to go back and forth, but to go back to the implementing regulation, tab 2, page 105, there's Article 3 and subparagraph 2.
$185.
I'm sorry, it's 105.
Thank you.
And can I just direct the court to paragraph 2, first paragraph on that page? And this is all really just to make the point that the mechanics of the implementing regulation, the nuts and bolts, do appear to clearly presuppose an application at least that has been made. So certainly to that extent, the implementing regulation supports the reasoning of the upper tribunal judge rather than, I say, that of the appellant. The appellant makes an alternative argument that...
Sorry, just before we leave that, what is the relevant institution within the meaning of Article 3.2? Is that a defined term, or do we just have to gather it from the context?
It's not defined.
Defined in the main regulation, isn't it? page 12.
You're probably
That
right.
may not work.
I'm sure you're
There's a
right.
No,
competent
that may not
institution.
work.
Well, we have a competent institution there.
And what
Yes, I would rather assume that that would refer to the
Sorry.
competent
The word
institution.
This is relevant. Just says relevant.
Yes, sorry.
This is a provision that applies to all benefits.
Institution is at P, isn't it? So
Yes.
that's body or authority, relevant institution.
Yes.
Yeah, I think they probably simply meant give it to whoever needs it for the money to be paid.
Well, I'm sure that's what it boils down to in the real world. Yes.
I doubt that when they sat down in Brussels or wherever, that they were really thinking, dear me.
Yeah.
So can I just, in relation to the appellant's backup argument on ground 2, which is that, well, if an application is required, we can just notify the Spanish authorities and that counts as an application. No problem.
You say no.
I say the difficulty that arises with that is, I say the procedures clearly presuppose an application, and then Article 9 provides for a mechanism for member states to agree procedures other than those provided by the implementing regulation, and notification requirements and so forth. So perhaps my lords, my lady might just take a moment to look at Article 9, page 108. So I say that would be a pointless provision if member states could simply interpret the requirements of the implementing regulation out of existence. I don't know if perhaps my learned friend will tell us that such procedures have been established, in which case that's an answer to that point. So those are the provisions of the implementing regulation which now, it's important to bear in mind why I'm actually showing you these provisions, and the reason why I'm showing them to the court is because of Article 68. So Article 68 sets out priority rules in the event of overlapping. So this is on the premise that the court's not with me, that Spain is not a competent state, and that there is a possibility of multiple entitlements to benefits.
If, as you say, the key, the founding stone, is the competent state,
For the entitlement, yes.
you have the entitlement, why have they gone to such trouble to keep hanging on about the whole purpose will be the applicable legislation?
Because the applicable legislation tells you what the competent state is. You look
Sorry?
the applicable legislation tells you what the competent state is. So in this case, the competent institution is the institution with which Miss Carrington was insured at the time of the application. What does that mean? At the time of the application, whose legislation applied to Miss Carrington? Whose legislation did she have to satisfy to get that benefit? It was UK legislation. So from that, we know that the competent member state is the UK.
So you accept that relevant legislation comes in, it's a question of timing.
It's a central concept. I accept it's a central concept. But
So the debate, what divides you, is whether it's relevant legislation at the time the application is made, or relevant legislation upon the move.
well, what I say is that the words that are used in Regulation 883 in terms of entitlement to family benefits is competent state. And that is given a meaning by the regulation.
Article 67.
Article 67. That's given a meaning by the regulation. We have case law on how to approach that. And the answer that comes out is, as I say, it's the UK. We don't simply take the concept of applicable legislation and apply it in an abstract sense. It has to be pinned down to what the regulation actually provides.
But you say, well, the problem is Article 11 appears to be the mechanism for telling you whether person A, the applicable legislation is state B. That's the purpose of 1, of 11, 1 to 4. But you say, no, that's not right. Because once you've applied for a benefit once,
Until you apply again.
until you apply again.
Exactly.
So you can only apply first time round to the applicable state legislation.
Of course, absolutely.
So when you make your first, if you don't choose, you're born in Poland, you don't choose in Poland, not enough zlotys in it, and you're planning to go to Germany, you go off to Germany, your child is now 2. At that stage, it is the applicable law because you haven't yet applied for one in Poland, and you make your choice to apply in Poland.
It doesn't matter whether or not you've applied in Poland. The basis on which the legislation of Germany becomes applicable.
You can always choose.
I'm sorry?
You can always choose. You can have it in Poland for 2 years, then go and have it in Germany for years 2 onwards.
Well, if the legislation applies to you, it means you're residing there or working there. So,
provided you apply and make it the competent state. It doesn't apply automatically because the definition of applicable state meets your circumstances.
no.
The whole definition of applicable state is something quite different. It's a separate, additional thing that must be satisfied. You couldn't insist on getting it for a country where you went on holiday for 2 weeks because that was never the applicable legislation.
No. In the context of family benefits, and I have to accept, I'm assuming, as the regulation does, that you need to make an application.
Yeah.
In that context, until you apply for the benefit, which is the only way of obtaining it, the regulation is not interested. It's not interested in the fact that you're simply in Spain. It's only the fact that you're in Spain and seeking child benefit in Spain that is of interest to the regulation.
So the rules kick in the moment you apply, and then you ask yourself, can they get it, or are they forced to get something else?
Yes, and if they get it in Spain and they also have it in the UK, the regulation deals with it.
Then deal with the overlapping. Yeah, I'm with you now.
I see. But in order to make the application, if I understood you rightly this morning, there is a prior question, which is the applicant, would-be applicant, has to ask him or herself what is the applicable law.
Yes, that is the case.
Because you can't, until you've answered that question, you can't know what, in fact, what are the conditions you have to satisfy and who you need to apply to and all and so forth.
That is the case universally, with the exception of those cases that my learned friend took the court to, which allow for a state to provide benefits for those which have a close connection with it without interfering with the Regulation 883 framework. But in terms of Regulation 883, in general, yes, you have to know which state's laws apply to you.
So it's always dependent upon a choice, the person choosing to apply, but he or she will only be able to apply if they're able to satisfy at the moment of application that the state they've applied to is the one that's in the applicable legislation. So that's the purpose. When a person decides to claim Social Security, they would have to do so to the state at that stage.
Yes, yes. And it is a choice, but I also don't, I don't want to overstate, or I don't want to create a risk of overstating that choice. The person has moved, there's a choice. If I stay in the UK for my whole life, I have a choice as to whether to apply for child benefit in the UK at whatever point I'm eligible to apply for child benefit. All the regulation does is that it lets me take that choice with me as I move around the EU and create some favourable rules in terms of retention, so that I have an element of being able to decide between entitlements.
If you were lucky enough to be born in a state with high child benefit, you can keep it, or work at some stage in a state with high child benefit, then go apply then and keep that in the bargain bag, and take
it does give you the ability to do that. It does. Yes.
I wonder what the impact of this is. We talk about a choice, and in one sense it is, but there may be people for whom it is no choice. They're in England, they're on the breadline, they have to have child benefit, they have to make an application.
Yes.
And then they are stuck with it. So for many people it's not a choice at all, but the consequences are nevertheless very significant.
Well, you say it's not a fixed choice.
No, they're no more stuck with it by virtue of the regulation.
Yeah. Because you say they can go to any other state which is applicable and choose. It's not a fixed once and for all choice.
It gives them greater latitude.
It's a greater right. They can free move and pick the best benefit system available.
Exactly.
And they could presumably have child benefit from France, maternity benefit from Germany.
And if there are overlapping benefits, that's dealt with.
Yeah.
So I've dealt with the aspects of the regulation which presuppose an application, and I think it's come out how that relates to the competent institution point and the way that the regulation is framed overall. Can I just take the court then to the CJE authorities, which I say support the stronger proposition that a learned friend ascribes to paragraph 9 of the upper tribunal judgment. That is to say that until the person is actually in receipt of benefits, then overlapping provisions do not kick in. And those, so the most important is Schwemmer, tab 11 of the authorities bundle. And I'm conscious that the court was taken to this, but I just want to emphasise a part of the judgment that perhaps wasn't emphasised as much as I would emphasise it. So the provision under consideration is at page 548. 548, paragraph 14. And then the reasoning is at 560 to 561 as to when that provision kicks in. So 51, Article 10, intended to resolve cases of overlapping rights to family benefits. That's what Article 68 now does. And the court says at 52, it's not enough for such benefits to be due. Next paragraph, which is 53, relying particularly on the second sentence. It's necessary for the person concerned to fulfil all the conditions as to both form and substance, which may include the prior application has been made. I'd also draw the court's attention to the last paragraph, which is 55, and particularly the bottom half of that paragraph.
And what do you get from these?
So the overlapping provision does not kick in if the benefits were not paid. That's what it says. And that's
but if the benefits were not paid on the ground that the conditions were not satisfied.
Yes, that's the point I made earlier, which is what's the practical difference between all the conditions having to be satisfied and the benefit being paid. So it may not matter, but
So suspension does not take place.
yes, that's the provision under consideration. There's different wording here. The effect of the way that the priority rules take effect here is by ascribing a priority to different benefits, but the structure and function of the overlapping provisions is, I say, materially similar, materially the same.
But really, it's a bit difficult to extrapolate from this. They were trying to help the woman here. The man hadn't made the claim in Switzerland, and the Germans were trying to dock her the amount in Switzerland.
Yes.
And they said, aha, they can't do that because he hasn't yet met all the requirements in Switzerland. It's a big leap from that to say the key question is whether the money is paid before the overlapping benefits apply. All this says is the overlapping rules certainly don't apply if even the rules of the state concerned haven't been met.
Well,
You say we should read what you suggest into the phrase "were not paid." So
The benefits were not
were not
paid.
claimed. It says "were not paid."
yes, that's the support for the broader, the stronger proposition. I take the points made. Trepkowski is If I just take the court very quickly to Tripkowski, it's more of the same really. Tab 15. Page 660, paragraph 32. Essentially, the court is just repeats what was said in Schwemmer. And then if I could just ask the court please to read over the page 662, paragraph 45 to 49.
We're dealing with the second question here, which is whether the third sentence of Article 60 must be interpreted.
Yes, I took the court to Article 60 earlier. It's just drawing out the distinction between making the claim and actually the right to receive the benefits.
So the question is whether an application for family benefits submitted by the other parent should be taken into account, and the court says not unless not only are the conditions met but the benefits granted.
Exactly. So if the court feels it necessary to and reads the upper tribunal judge's decision in the way contended for by my learned friend, I say that those cases do provide authority for that approach. Well, I'm coming now nearly to the end of my submissions on Regulation 883. I just wanted to flag one point, and I'm conscious of the concerns raised by my lords in relation to Ground 2 and the potentially academic nature of it. But there is one point, if the court is going to wade into that, there is one point that I'd just like to flag. My learned friend clarified that, and she'll correct me if I misstate what she said, that the way in which HMRC categorise child benefit that's paid by another competent state, whether it's on the basis of residence or not, is on the basis of I think what was said is that if the person's working, then it's treated as being paid on the basis that they're working.
Yeah.
Thank you very much. Now, I don't think this is in the papers, but I know from instruction that Miss Carrington, at the time she applied for child benefit, was working.
Where?
She was working here. I'll be corrected if I'm wrong, but that's a question that I specifically asked.
I've seen something. She was working as a midwife.
She was indeed. She was indeed. I'm not inviting the court to adjudicate anything, but it's just to be conscious, because if that's correct and the approach that HMRC take is taken to Ms. Carrington's position, then in any event the UK would have priority.
I think they were trying to protect a future case. If somebody had moved with sickness benefits or whatever under Article 7, and then having been ill or whatever, then started to work in the new state, then they would say all bets are off and you go back to square one. I think that's what you were guarding against, was it?
Yes, could I just clarify, when I said that that's how HMRC operates, it's at the time that the priority rules apply, rather than the basis upon which what the person was doing at the time they first claimed. So in this case, hypothetical situation, by the time she gets to Spain, she's not working, it doesn't matter that she worked in the past. So it's what's happening now, essentially.
But if she works in Spain in the future,
yes,
things would change.
exactly.
That's what you're trying to guard against.
Yes, exactly.
Just flag that I'm not making any submissions really on it. I just wanted to flag it in case the court does end up dealing with that point. The last point I just wanted to make is that there's a suggestion in my learned friend submissions, the last point in relation to Regulation 883, in my learned friend submissions that there is something particularly relevant to be inferred from the fact that Article 59 has this mechanism for dealing with multiple payments in relation to family benefits, and that indicates that family benefits are in a special category where you can't retain rights in the way that you would with sickness benefits. And I would simply suggest that a more prosaic reason for that might be that it's given the nature of what one receives payment for, a child benefit, that there is a greater likelihood that a person moving around between member states would be making multiple applications for child benefit because your child moves around with you, essentially.
But if you're right, then Article 59 has a role. It has a role when you decide to switch mid-month from Spain to Germany.
Yes, it does.
It's higher.
Yes.
It's got a more limited factual application, but still meaningful.
Yes, absolutely. My lords, my lady, those are my submissions. I think in terms of the individual grounds, I've set out the position in my skeleton argument. But my lords, my lady, you have the primary case that I say the only competent state that we have to grapple with here is the UK, and it's not been shown that Spain is the competent state, and I've explained why I say that is the case. And if I'm wrong about that, then Article 7 in any event protects Miss Carrington's position. The overlapping provisions, well, as a matter of principle, I would say that the overlapping provisions would not displace Article 7 here, but applying them to this situation, they simply don't bite. No application's even been made for a benefit in Spain. Article 10, for the reasons I give my skeleton argument, doesn't add anything, so ground 3, I say, doesn't add anything. In my submission, my interpretation of the regulation is more closely based on the language of the relevant provisions and gives effect to the framework in a coherent manner that's consistent with the principles that are said to underlie it, and is also consistent with the case law of the CJEU, in particular Tolly.
So in particular,
Tolly. My lords, my lady, unless I can assist.
Well, thank you very much indeed, Mr. Haptestasi. And just before you sit down, I would like to say on behalf of all three of us how very much we appreciate your public-spirited work in taking on this highly complicated but very important brief on a pro bono basis. I mean, it really is in the highest traditions of the bar, and we really appreciate it.
My pleasure. And if I may share those thanks with my solicitors, Hogan Lovels, who are also acting pro bono.
Absolutely. And I'm sorry, your solicitors are, I wasn't quite sure who they were, but not because I'm not told on.
Very grateful. Thank you.
No, I'm sorry, could you just tell me who you are?
It's Hogan Lovels.
Oh, it's Hogan Lovels.
Oh,
yes. Thank you.
They've acted pro bono as well.
Yes, they've come.
You've all acted pro bono.
We've all acted pro bono.
Well, my hat's off to all of you. I mean, thank you very much indeed.
I'm grateful.
Because really, this case couldn't have had a proper hearing without that. Well, I know we had the advocate for the court, and we would have had her submissions had you not stepped in as on a pro bono basis. But either way, it's very much appreciated.
I'm grateful. Thank you very much.
Thank you. My lords, my lady, and before I begin, could I echo those thanks on behalf of my client, who had also been hopeful that we would be able to get representation on the other side precisely for that reason. So we're also very grateful.
Yes, indeed.
I'll divide my reply into 5 parts. The first part is this. Could I just invite the court to take a step back for the moment? The position is common ground that under 1408, for sickness benefits, there was a right to keep such a benefit even on a change of applicable law. That's common ground, Tolly. And it's also common ground that for family benefits there was no such right.
Sorry, no such right for family benefits before Article 883.
Yes,
Yeah.
that's common ground. Again, taking a step back, the court has also seen the Travo, which give no indication whatsoever that there was intended to be a fundamental change to family benefits. Ditto the recitals to 883. And similarly, nor is there any indication from any of those materials that the position was intended to be different for sickness benefits. So taking a step back then, from my client's perspective, from the perspective of the Secretary of State for Work and Pensions, there's nothing at all to support an argument that under 883 the position for cash sickness benefits is now less generous. And one can imagine, and indeed the Secretary of State did argue that initially, that claimants would have said, well, that's not right, because 883 is not less generous to me. So I don't care how you do it, but you've got to let me take my benefit with me, even on a change of applicable law. So the Secretary of State for Work and Pensions has accepted, after a lot of thinking and litigation, okay, we'll accept that Article 7 is the basis for export. That's what the Secretary of State has accepted. But if in future a court says, well, it's not Article 7, it's a different provision, so be it. The point is that the Secretary of State accepts that 883 effectively carries the Tolly right across, because otherwise, if it had been intended to be less generous, it would have said so. Similarly, taking a step back from HMRC's perspective, there's nothing to say that anyone intended to affect a dramatic change for family benefits. So taking a step back, what we have is two departments quite properly saying, well, our benefits are different and the established position is different. So that's the taking a step back for a moment point, that I accept that then the court rightly pressed me on why the approach is different. And I've addressed that, I hope, and I'm going to summarise the position there. But one has to remember that the headline point is that DWP, unless it was going to say, well, 883 you can't do it anymore, sorry, DWP, there has to be a basis for it, and it says Article 7. But if a court in future, for some reason, perhaps there'll be a reference to the ECJ says, oh no, that's not how it works, Article 7, but you still export sickness benefits for another reason, so be it. The point is, entitlement carries on under 883.
And the one thing we can't do is make a reference, of course.
No.
Tempting, though, otherwise might be.
Yes, indeed. So that's my taking a step back point. The second point in reply is to address Article 7, which, having made that taking a step back point, there is in my submission nothing inconsistent in the two approaches. They're different in result, but that doesn't make them legally inconsistent. consistent. And the point is this, that both departments accept that Article 7 has to be read subject to other provisions. But there aren't any for sickness benefits, in effect, to read it down if it's given its broader interpretation. But for family benefits, once it's read with other provisions, it's quite clear that it doesn't have the same effect for family benefits. And when I was making my submissions yesterday, I said that there are three possible interpretations one can give. One can give Article 7 the construction advanced by my learned friend. One can give it the construction that for family benefits, not sickness benefits, but for family benefits, it only bites where the paying state is the state of applicable law. And my third construction was this, that in the context of family benefits, it bites for that period under Article 59 when the old state has to carry on paying. So in my submission, that third interpretation gives clear meaning to it while respecting the other provisions and giving coherence to them. In relation to, still on the second point of my reply, in relation to Article 7, my learned friend made a point about the wording. He said, well, it's clearly about acquired rights because those words that it uses are all about taking things away. But the answer to that is, I showed the court yesterday the case of Stewart, which is about the predecessor for Article 7, Article 10, and what Stewart says is, no, it's not just about taking things away, it also applies to acquisition. So that's a good illustration of the danger of a textual approach, particularly in this context, and it also, in my submission, completely undermines my learned friend's point that that's what Article 7 must be doing, because that's the words that it uses.
I'm not absolutely sure I follow that. I mean, it may be the case that if one looks at the express text of Article 7, the actual words one reads there do, at first blush at any rate, look as though they're talking about the removal of something that exists. And then you get Stewart, which is an extension of that, admittedly, but that's to actually say, well, we're not just concerned with taking away, but also to acquisition in certain, perhaps fairly narrowly limited types of case. But I mean, that doesn't necessarily detract from the first point, does it? That the main focus of the article is on removal of something which has already been acquired in some sense. I
maintain my point about Stewart, but I would also add that on my second or my third interpretation, it still works, because if for family benefits it's biting in a situation where the state is still the state of applicable law, then it is taking something away because the person has the benefit, and the state then says, right, well, you're not living here anymore, and the answer to that is, yeah, but you're still my state of applicable legislation, so carry on paying me. Article 7 says so. I accept that for the reasons I gave in the first part of this reply, DWP adopts a broader construction, but I've addressed that in my first and second submission. But I say the wording actually doesn't advance between my learned friend's construction and my second construction. And the heading, of course, isn't keeping benefits that you've got when you move, it's waiving of residence clauses. The third part of my reply addresses Article 67, and I submit that this is crucial because it's a major underpinning of my learned friend's case that Article 67 is different from Article 73, and that the legislature deliberately changed it so that it would work to allow a Tolley type analysis. And my learned friend said in terms that Article 73 did not allow for a Tolley analysis. So if we were standing here and Article 67 used exactly the same words as Article 73, then my appeal would succeed, I would submit, because Article 7 would have to be read subject to that. But for a number of reasons, it's wrong to submit that Article 73 is materially different, with a materially different effect from Article 67, and I say that for several reasons. First, look at the title of Article 73. That point was taken in argument. Article 73 essentially talks about applicable legislation subject to the legislation of. They mean the same thing, but in the title it uses the word competent state. Second, despite what my learned friend says about Moser, that is the Court of Justice telling us they're basically the same, and in my submission that would be a very odd and ill-advised thing for the court to say if they were in fact different in this very material respect. And indeed I took the court to Pennings yesterday. Pennings agrees as well what Article 67 and 73 are doing. The third reason my learned friend is wrong about Article 67 is because if he's right, it's a major change which doesn't appear in the recitals or the travo. Fourth, as my Lord Justice Lewis pointed out in argument, other surrounding provisions use the language of applicable legislation, particularly Article 68. So Article 68 is premised on the whole thing being based on applicable legislation. My learned friend places great weight on the definition of competent institution. He says, well, one has to read Article 67 by reference to the definition of competent institution, and he relies on Tolley in that respect. The difficulty with that is that Tolley was all about transfer of residence during sickness. That was the heading of Article 22. And the only way to make sense of that is to say, well, obviously the competent state is the state that you start off with, because you've become sick, you're already sick, and then you transfer your residence during sickness. That can't be extrapolated to this situation. Transfer of residence during having children, or it's not how it works. But that's why, and when one looks at Tolley carefully, both at the Advocate General and at the court, when they are interpreting competent institution, they do so in a very context-specific way. And we say that there's a simple way to address this, and it's the corrected version of paragraph 29.3 of my reply, which is, well, it's the state to which you should be applying, because it's the state of applicable legislation. And my learned friend took the court to Article 81, and that says if you make an application to a state and it should be made to another state, it gets forwarded. So, finally, in relation to this point about Article 67, if the respondent is right about this, the person can't make a choice, because if the answer is, well, Article 67 says it's the competent institution, and that's the state where you first applied for benefit, then Spain will say, sorry, Gov, I'm not the competent institution because you applied for benefit previously, so it can't be me.
But I think your opponent would say it's the state where an application is made, and if they choose to make an application later, he would say that you put in the word first, I imagine. Yeah.
Yes, and of course, I mean that then is also that's not the language, the very strict language of the definition of competent institution on which he's relying. But of course, we then come back to my fundamental principles. A very fundamental principle of this legislation, which appears in case after case, is that a person can't choose. So it just doesn't work. So to draw all of those strands together, what my learned friend is doing is he's letting the definition tail wag the substantive dog, because one has to take a step back, look at Article 67, what it says, look at Article 73 that it replaced, look at all the other matters that I've replaced, and then read the definition of competent institution. And I agree with my learned friend in this respect. He says, well, Article 67 is doing two things. One, it's reflecting that the application is made to the competent state. Two, it's providing for the family members living elsewhere situation. No difficulty with that. That's my submission. Where we disagree is what Article 67 says. And in my submission, what it says very clearly is that entitlement to family benefits is based on applicable law. My learned friend handed up Coppola, which he didn't make submissions about, but
You say it's been handed up. It's actually sitting sort of halfway, I think, en route to us. But I hope before we go, we can take possession of it.
For the court's note,
Yeah.
I read it a long time ago because it's considered in Conavod, but I've just read it again now. That there is a point I draw from this, which is directly relevant to this issue about definition. Just in terms of the facts, Mr. Coppola worked in the UK, then he worked in Italy, and then he became unwell and wanted to claim an invalidity benefit. And the UK tribunal said, well, why can't he have the UK's invalidity benefit? And it goes off on a reference, and essentially the Court of Justice says, well, he can't have the UK invalidity benefit because UK legislation isn't applicable. That's the background to the case, and it's one that I relied on in Conavod. But importantly, for present purposes, if the Court looks at paragraph 10 of the judgment rather than the Advocate General, what it's clear is the Court is saying that the definition has to be applied in a context-specific way, and the Court says in paragraph 10, by reference to the fact that a worker is subject to the legislation of a single member state only. So that precisely supports my position here.
And going back to 1Q, whichever of you is right, the wording isn't enough. You've got to read something else in. If Mr. Haptis-Lassie is correct, it has to say something like the institution with which the person concerned is insured at the time of the latest or the most recent application for benefit. Whereas you say what it really means, the institution with which the person concerned is insured at the time when an application for benefit falls to be made. And you know it falls to be made when the applicable law changes. So each of you, in a way, is having to treat 1Q not as textually dispositive, but as a first stab.
Yes, and exactly that. And we say our position is supported by Article 81, which essentially says if the claim is made to the wrong state, it needs to be forwarded on.
I've forgotten 81. Oh yes, you did show us that, yes.
So that was the third part of my reply. The fourth part is just briefly to address Article 59 and the implementing regulation. I think my learned friend said that he couldn't see a situation where a state's law would be applicable, but it wouldn't be competent.
I thought you'd give us some examples.
What I say is, I agree that for family benefits, either applicable law changes and at the same time competence changes, or competence changes on its own without the applicable law changing. But the primary focus in my submission of Article 59 is applicable legislation, and one sees that when one looks at the original proposal for the legislation, and it talks about being subject to the legislation of. So we submit that Article 59 makes the provision crystal clear. There's nothing in there about choosing. It's very black and white. It says if this happens, the state stops paying. And I've already made my submission that saying a person can choose fundamentally drives a coach and horses through this legislation, which is designed to ensure certainty. On a practical point on the implementing regulation, my learned friend said, are there procedures in this type of case? There are. We send the application to the other state, and there are standard procedures and an electronic exchange system which has been developed over decades to deal with these exchanges, and there are special documents called structured electronic documents, so that there is a framework in place. So that addresses that point.
This is, as it were, bilateral agreements between the departments here and their counterparts. Is it just in Spain or other member states as
No,
well? I would
everywhere.
imagine?
So all of the member states have put in place this system of structured electronic documents and an electronic exchange system which has been developed over decades, which is basically how they all communicate as they need to about claimants and their claims and so on. So it is all in place, but one gets the 883, then the implementing legislation, and then the practical arrangements underneath it which fulfil the requirements of both. Yes, the body that's called the Admin Commission is it's all agreed there.
Yes, thank you.
On the final part of my reply, I just want to deal with a couple of submissions that my learned friend has made about the case law. So the first case he dealt with was effing. I'm not taking the court back to that case, but his submission was premised on Article 67 being different from Article 73. And the fact is that in effing, the child did have a benefit and it was taken away from him. So I say all of those cases, including effing, strongly support my position.
What about the Finnish woman whose name's difficult
Coming
to
on
remember?
to her, yes,
Oh, right.
Chris Jarvis. So
Yeah.
what there is in that case is a passing comment at the end of the judgment, which basically says Article 10 doesn't apply, but it's a comment which is shrouded in mystery. So the difficulty is the court doesn't say this would all be sorted out by Article 10. It's not clear why it's saying it.
It seems to be saying she doesn't get it under Article 10 without saying any more than that.
Exactly. So one can't really take a great deal from that. And I would add, of course, that the difficulty we have is that there's no analysis from the Advocate General on the point, because he thinks it's a sickness benefit.
Yeah.
So one doesn't have the detailed analysis one might expect from the Advocate General, where one would hope the Advocate General would say, well, actually, family benefits, it's different.
So it's Delphic, really. It just says this case
Delphic.
can't win on Article 10, but without expressing a view as to what the consequences would be
Yes.
if Article 10 were amended or 22 removed.
Precisely. And against all the other case law, it can't really assist this court in my submission.
I mean, if it's not disrespectful to say so, I mean, that's the kind of slightly mysterious comment one does sometimes find in judgments of the court, maybe partly because they are, so to speak, a lowest common denominator factor that everybody is happy to sign up to, and
Yes.
occasionally that
Exactly.
one ends up with slightly mysterious looking loose ends, which may have been inserted for that kind of a reason.
Exactly, and in fairness to my learned friend, I didn't understand him to say that it was a killer point, but in my submission it really doesn't take things any further forward, and one would just, it's shrouded in mystery.
Well,
Delphic.
it's Delphic rather than mysterious, given the
Mysterious.
European Union.
Delphic.
Delphic, perhaps a more.
The
Yes.
final case I just wanted to mention is Trakowski. I'm not going to take the court back to that, but if and when the court does look at it again, could I just invite the court to note paragraph 38, where the court describes itself as giving a combined reading of Article 67 of the main regulation and Article 60 of the implementing regulation, which is what I'm inviting this court to do. Read everything together.
Which paragraph?
Paragraph 38.
Thank you.
And then the other point to mention, my Lady Justice Carr made this point, that insofar as my learned friend relies on those later paragraphs in relation to the Schwemmer point, that's not legitimate, because those later paragraphs are addressing a very complex question, which is framed at paragraph 42. And at this hour, I won't take the court back to the question, but it doesn't assist so far as the issue in this case is concerned. And so those are my submissions on the case law, and so I round things up by saying I come back to the headline points I made at the beginning of my submission, and I submit that now that we have looked at everything in detail, I have made those points good, and what I say in paragraph 30 of my reply, drawing all the strands together, holds good. So for those reasons, I invite the court to allow the appeal.
Thank you very much indeed.
I'm
Sorry.
so sorry to be difficult, but could I just make one point in relation to something that my Lord Justice Lewis said about my submission? Would that be acceptable?
Yes, by all means.
I'm so sorry.
Yes, no problem. No.
The point that was made was that my analysis requires words to be read into.
1Q, the most recent.
And I just want to make it clear, and Tolly is a good case to go to for this, that there is an important... The analysis in Tolly does not do any violence to the one applicable legislation principle. The point is that one has an applicable legislation at different points in time. So if I apply for... if Miss Carrington applies for child benefit in 2000, at the point she applies, the one applicable legislation rule means that only the UK's law can apply.
Yeah.
If she then applies today,
Yeah.
the one applicable legislation rule means that only Spanish law can apply. So you have two competent states because you're taking a snapshot of the applicable legislation at different points. That's the only point I wanted to make.
Yes, thank you. Do you want any final word on that? No.
Happily for the court, no.
No.
Most grateful.
Well, I think in that case, unless my lord or my lady have any further questions, it only remains for me to, really genuinely thank you both very much indeed for the excellent submissions we've had the pleasure of listening to over the last couple of days. And very much also those thanks extend to those behind you for what must have been a huge amount of preparatory work and general assistance on the very technical issues which crop up, and answers to all the questions I'm afraid we've been firing at you. But I assure you that's in an effort to try and understand what this case is about and see our way towards a solution. And that in absolutely no way reflects any reflects adversely in any sense on the excellent submissions we've had. So you obviously will be reserving our judgment. You've given us a lot of food for thought and plenty to occupy our time for some little while ahead. We will hand down our judgments in the usual way. We'll send out the draft judgments in due course, inviting corrections of obvious errors and typographical mistakes, but not any re-argument. And then the hand down, I think in accordance with the current practice, will be remote unless we tell you to the contrary. We hope you will be able to agree in order. If you can't, brief submissions in writing to be submitted in the usual way, which we will deal with on paper, again, unless we notify you to the contrary. Just a couple of housekeeping points. Firstly, I know there is that case that Mr. Abdelazi handed up, and can we just have it? Can it now reach us as opposed to getting stranded in no man's land? Thank you very much. And also the note, which I know we're expecting from you probably by tomorrow morning. Will that be acceptable?
Indeed. And there is another housekeeping point that I mentioned to my learned friend, and I'm so sorry, I meant to address it in my reply.
Thank you so much.
Which is that there is a pending reference in the ECJ that was drawn to my attention at lunchtime. I'm going to get more information about it, but I will send the court more information. And if it's relevant, we can make submissions as
Well,
to.
you have to be careful because there are provisions about the extent to which this court can have regard to
Yes,
decisions of
indeed.
the European Court of Justice following the departure of this country from membership of the European Union.
Indeed.
So you've got to be careful about that. It doesn't mean we can't, but
Yes,
it's got to be appropriate in regard. Forget the phrase.
Indeed.
Yeah.
Yes.
Sorry.
Yes, I mean, sorry, I mean, on the related point, it is, I think, common ground that this particular case, this appeal doesn't turn on any sense in post-Brexit law, because we're dealing with events which took place and judgments which were given well before Brexit Day. So that is correct, yes. So that's one less thing we have to worry about. Good, well, on that note, let me thank you again, all of you, very much indeed. And we will now rise.
There is one other important matter, my lord. On behalf of the bar, could I congratulate your lordship on an illustrious and distinguished career, wish your lordship well for his retirement, and no doubt your lordship was delighted that such an easy case would be the last case.
That's extremely kind of you. Thank you both very much indeed. I'm afraid you may yet have to suffer from me as a retread in due course, but we will. But anyway, that's much appreciated. Thank you.